Dr. Megan Woods.
Thank you, Mr. Chairman. And in part 3, I'd like to take a call on clauses 24, 25 and 26, which sets out the appeal rights that exist under this legislation. And Mr. Chairman, that these parts of the legislation were subject to a number of submissions at the select committee phase, and the submitters the people who did take the opportunity to submit on these clauses and the appeal rights that are contained in this legislation were very much opposed to the limiting of the powers of appeal rights, because what this legislation does is carry over some provisions that were there under the previous legislation that defined regional governance in Canterbury, so the 2010 Act, and replaces requirements in section 55 under the 2010 Act. And what it does is take away the rights that from Canterburyans, the rights that everyone else around the country has, and that is the right to make appeals to the Environment Court. And what this legislation puts in place is that these appeals need to be to the High Court. Now, Mr. Chairman, this isn't some small, dry technicality buried in the 20-something clauses of a piece of legislation. This fundamentally changes the way in which people can interact with the decision that their local regional council is making. Because as we all know, Mr. Chairman, that the Environment Court is a special court in New Zealand. Not only does it have specialist judges, but that it also is assisted by specialist commissioners who have expertise in resource management, in planning, in environmental planning, in engineering and in science that can be called in. And that this is a court that can take a much more inquisitorial approach to any appeal that is put before it, unlike the High Court, where these appeals will be on matters of law only. So whereas people in other parts of the country can go and appeal a decision of their regional council and what they're doing on the basis of the substance, on the facts of what is actually happening, Canterburyans are limited in their appeal rights to only being matters of law. And this fundamentally changes the way in which this legislation operates. This is, of course, a change that the Minister, who's sitting in the chair, has been wanting to get across the line in terms of RMA throughout the country, but has been unable to get that across the line with his support partners. So what's he doing here is in clauses 24, 25 and 26, he's trying to impose it in some kind of pilot study on Canterburyans. And I do not think it's good enough that just because the Minister cannot get his RMA legislation over the line in this Parliament, that he decides that Canterbury is some kind of petri dish where he can put in place different kind of appeal provisions, such as we're seeing in clauses 24, 25 and 26 of this legislation. And I'd like the Minister to take a call and explain to us why it is that Canterburyans will have lesser appeal rights than their contemporaries and their compatriots in other parts of the country, because this does have far-ranging impacts for how it is that Canterburyans are going to interact with their regional council and what their rights are. I'd also like the Minister to talk about what alternatives might be available to Canterburyans to take an appeal to the High Court, because whereas someone could access funding through the Environmental Legal Aid Fund that is established to aid people in taking appeals to the Environment Court, will there be a similar fund that Canterburyans that want to appeal a decision that's made under this piece of legislation but are forced to take that appeal to the High Court on a matter of law, which is a much more expensive process and actually will limit people's ability to have access to justice around this, but will there be a similar fund to the legal aid fund that is available for people taking Environment Court cases to that court? Because, Mr. Speaker, this is about access to justice. We are seeing that this is a government that is eager to shut down people's access to the courts and their ability to get their day in court and to have those questions answered in many aspects of Christchurch and Canterbury at the moment. And I'd like the Minister to take a call on that, and I look forward from hearing from him, Mr. Chairman.
Mr. Chairman.